Hi, my name is Jubin with Dana Legal Services, and in today's video we're going to specifically address the concern that people have after they have filed a patent application, a non-provisional patent application, and the patent office has examined it and rejected their patent application. Sometimes people panic and they're like, oh my God, my patent's been rejected, what do I do? Well, first of all, I hope you're working with a patent attorney, because if you're not, it's going to be hard to understand the rejection and know how to deal with it. But in the event that you're not working with a patent attorney, we're here to help you. Come see us or go find yourself a patent attorney that will work for you. But again, when the patent office examines your patent application, I'm going to break the rejection down into three main things. And it's based on these three things that you have to prepare a response or file a response to the patent office. The first type of rejection, and by the way, all three of these rejections can appear in the same office action, the same rejection. And some rejections are labeled as non-final, and some rejections are labeled as final. And by the way, even if they're labeled as final, you can still continue through a process to have your application examined and reviewed. You just got to know what to do and how to do it. But anyway, let's talk about the rejection in general, the types of rejections you get. The first type of rejection you get is based on 35 USC, United States Code, Section 101. So Title 35 USC 101. That rejection is basically the patent office telling you that these things that you have prepared and filed for patent protection on are not the kinds of things that the patent office grants patents on. They're not saying that your idea is not new or novel. They're just saying that your idea is not subject to patent protection because it constitutes matter that cannot be patented. An example of that would be a mathematical formula. Another example of that would be, for example, you discovered gravity. Gravity is not patentable because, it's something that exists even when the day it was first discovered, assuming the patent office existed. There are many different things that they say is not patentable. In other words, they call it mental steps or steps that do nothing more than provide abstract concepts that really can't be patented. So that's called a 101 rejection, and it's under Title 35 U.S. Code Section 101. The next type of rejection they give you is a rejection based on errors with your application that need to be corrected, that are not related to the substance of your idea, but more so related to how an application was presented. Typically, these errors come up a lot when people write their own patent applications and submit them, but they also come up sometimes when patent attorneys write applications and submit them. There could be something as simple as a typographical error, or you've left off a comma or a period somewhere, or they could be based on certain issues, like you didn't present every feature the way you should have when the feature was first presented in the claim. Anyway, all of these things are basically non-substantive type of rejections that you can deal with and address without too much difficulty. Sometimes they're the only rejection, and once you address them, you get your patent, your claims are allowed, and you can get your patent. Other times they're combined with other rejections so that, there's other things to deal with. So the first category of rejections was things that are not eligible to be patented. They have nothing to do with the idea of novelty or newness. They're just not things that can be patented. The second thing was rejections that are based on things that are have an error. There's an error with your application of somehow, especially as related to the claims. So there's some typographical error, or there's some error that needs to be addressed. And the third type of rejection is the substantive rejection. That's either going to be a rejection based on obviousness, or a rejection based on a single reference anticipation. And what does that mean? So these are two different codes in the law. So Title 35 U.S. Code Section 102, or Title 35 U.S. Code Section 103. We call these 102 or 103 rejections. And these 102 or 103 rejections are substantive rejections. These are rejections wherein the patent office is saying somebody has already disclosed your idea. Somebody has made public your idea. And this is why some people want to go do patentability searches, and we have a whole other video that discusses that. But at the end of the day, what this means is that there is a reference out there or a combination of references that disclose your idea, and the patent office will outline what it is and how it's done. And this is where your patent attorney can be very helpful in helping you work through these rejections to understand what they are, to understand the substance of them, and then how to address these when it comes to dealing with the rejections from the patent office. So, there are three main types of rejections when you get an office action. Don't panic, it's fine. They can be dealt with. Even if they're final, they can still continue to be examined through specific processes that we file to get. But anyway, there are three main types of rejections. One is in the category of, hey, this is not stuff that's patent eligible. You can't get a patent on this because these are not the kinds of things we patent. The second one being errors in your application that are minor, typographical errors, things with the claim language that needs to be addressed and corrected, or things that are not supported by the specification. So you wrote something in the claim, but that wasn't in the specification. And the third category is a rejection based on public documents that the patent office has been able to find that disclose or relate to your idea. Once again, I'm Jubin with Dana Legal Services. If you liked this video and found it helpful, please like and subscribe. And if you have any questions, reach out to us. We'd be happy to help you. Take care.